This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
I will take up first item number 9, which was heard yesterday, but the issue is same in all the matters.
No. Item 9 issue is different from Mr. Bhattacharya.
Very well, Mr. Bhattacharya.
Mr. Bhattacharya has challenged the rules itself. Here, not the rule has been challenged.
In all matters, the rule has been challenged, Mr. Bandhavata.
No,
In 9 also rule has been challenged.
but they are asking for certain. Anyway,
The declaration for
I don't mind, Melody. If
Yes.
you want to hear, I don't mind.
probably Mr. Mitra appeared. I heard this matter, but issue in all the matters is common. Issue is common. Yes. What is your case?
If the Lordship thinks that Mr. Mitra should be heard, I don't mind. He
No, no. All are to be heard.
Yes. Kindly turn to page 84.
Item 1, sir.
Sorry. Page 90, the advertisement.
কোন কেসটা করতে দাদা?
1. No. ওটা 90 12
Page
90.
এটা 9 লিখছে স্যার ঠিক আছে স্যার 1 নম্বর
Yes.
But I just meticulously placed the notification to show whether this is per se illegal. In terms of the judgment and order of the Honorable Supreme Court, therefore the source of notification is the Supreme Court order. Source of this notification is Supreme Court order. Read with order of 17th April in MA, so and so, has been directed to initiate fresh selection process to the post of assistant teachers, plus 9, 10, secondary and higher secondary, and to the post of assistant teachers 11, 12. The Commission and Government of West Bengal have already applied for review of the state judgment and order, and this exercise is strictly subject to outcome of the review petition and guidelines of the Honorable Court to be followed by the Commission. This notification is issued for conducting second level, state level test for selection to
Mr. Bhattacharya, there is no confusion with regard to issuance of this notification in terms of the order dated 3rd April 2025, read with 17th April 2025. Now, this is the admitted position. Now, the situation is this, that if 3rd April and 17th April are to be heard, are to be considered together, in that event, there are certain directions given. You draw court's attention to that order.
Yes, I am coming.
Yes.
Yes, I am very happy. Now, kindly come to me, Lord. Page 91.
That is the order of 3rd April 2025.
This is the notification dated, my lord.
30
This is 30th of May.
30th May.
Page 1991 is the part of the notification issued
Yes,
30th of May.
yes.
The kindly, my lord, note this. Eligible candidates
Which part? Page 19?
by page 91, not 19.
91 clause 2.
2. Eligible candidates minimum qualification laid down in rules 225. Where do they get rule 2025 in connection with the Supreme Court order first? Then,
Eligible candidates with minimum qualification.
apart from the
No, minimum qualifications in Rule 2025, which they have framed.
that the selection is being undertaken in terms of the Supreme Court judgment. The Supreme Court judgment says that 2016 selection should be done.
Where it is said by the Supreme Court.
Kindly come to me, Lord. The Supreme Court order at page 84, 85. But before that, now it's my duty to place before Lordship the division bench judgment of this court, which are before the Supreme Court.
Division bench judgment, Mr. Bhattacharya, come to paragraph 363.
Yes.
363, subparagraph 2.
আর এটা মূল জাজমেন্ট 6 নম্বর
All appointments granted in the selection process.
Yes. Now let us read, my lord, very carefully.
Yes.
363. তোমার বসে চুপ করে read.
363,
Yes,
2,
363.
Roman 2, I.
All appointments granted in the selection process involve violators so and so are declared null and void.
Then straightway come to 9.
Yes.
11.
Yes.
11.
11.
Roman 11.
SSC shall undertake a fresh selection process in respect of the declared vacancies. These declared vacancies are not vacancies
2016, 9, 10, 11, 12.
involved in this 3 selection process preferably within a fortnight from the date of declaration results of the ensuing elections. Then,
Then 13.
appointments for
Then 13.
yes,
SSC shall follow the rules governing
governing
the selection process
in letter and spirit. Therefore, that rules which was prevailing with the division bench was not declaring this law, and that rule was challenged before the Supreme Court. Therefore, all things were that this is 2016 selection.
where Mr. Bhattacharya, it has been directed that new rule cannot be framed.
What the court says that you initiate the selection process of the declared vacancies which were declared then, not new declaration, number one. And number two, shall follow
Yes, the declared vacancies.
governing the selection. Which selection?
Yes, rules governing the selection.
Selection.
SSC shall follow the rules governing the selection process in
Later
two
and
letters.
spirit.
Whatever the rules are there, that
Yeah.
is to be followed.
Are there?
That is to be followed. That is to be followed in the next selection process. Now the vacancies. Now tell me, if there are 1600, say if there are 100 vacancies in 2016 selection process for classes 9, 10, 11 and 12. Now in the meantime, if due to creation of certain vacancies, if vacancies are added, this cannot be taken into consideration.
Can I just, if your lordships permit me? Since your lordships have heard Mr. Mitro and your lordships have, if your lordship give me some time, I can clarify all these points.
I will hear you, Mr.
I
Bandyopadhyay.
understand.
I will hear you.
I will, these are the points I've already argued by Mr. Mitro.
No,
But
this was not a detailed
I
argument.
am not saying.
You are not there.
Well, at this stage of motion, there cannot be any details argument. If your lordship thinks that details argument, the matter is disposed of, I don't mind also. I don't mind also.
Allow me to hear,
No,
then
no,
I will hear.
I am
Yes,
saying,
I have-
I'm just saying.
I have that on basic prima facie issues. Therefore, this division bench judgment was declared at point of time, where the division bench says that
So according to you, Mr. Bhattacharya, first of all, the declared vacancies should be separated,
Yes.
and a selection process is to be initiated in terms of the recruitment rules of 2016.
because these vacancies would arise because of the cancellation of appointment by the court. Therefore, the court permitted you to do it afresh.
Now, this order must with the order passed by the Honorable Division Supreme Court. Let us come to that order.
Kindly come to order of the Supreme Court at page 83.
Paragraph 45 onwards.
Yes. Last question, got it.
Conclusion under
Yes.
the heading conclusion 45.
The last question relates to the relief, which it requires, whether it requires any modification. We find no valid ground or reason to interfere with the direction of the High Court that the services of the tainted candidates who are appointed must be terminated, and they should be required to refund salaries payments. Since their appointments were the result of fraud, his amounts to cheating, therefore we see no justification to alter. Then 646. For candidates not specifically found to be tainted, the entire selection process has been rightly declared null and void.
This is for a disabled candidate.
No.
46.
May I read it? Not specifically found to be tainted.
Yes. Yes, please read.
A selection process has been rightly declared null and void due to the egregious violations of the illegalities, which violates Article 16. As such, the appointments of those candidates are cancelled.
Yes.
However, the candidates who are all employed need not be asked to refund or restitute any payments made to them. However, their services will be terminated. Furthermore, no candidates can be appointed once the entire examination process and results have been declared void. Then next week. 43 is not necessary.
Yes, it's not necessary.
Now, kindly come to 48.
48 is also
not necessary. The disabled candidates mentioned in this regard, which
Yes, it is necessary. Please read 49.
okay, I am reading 49. My juniors will not insist to read 48.
Yes, I am also saying it's necessary. Yes, please.
Lastly, we address the case of the disabled candidates. Our attention has been drawn to such cases where impugned judgment had held the appointee. So and so shall be allowed to continue on humanitarian grounds. While
No, paragraph 49 says.
No, I was in paragraph 48.
48. Yes, paragraph 48. Lastly, we.
Lastly, we address the case of disabled candidates. Our attention has been drawn to one such case where the impugned judgment had held the appointee so and so will be allowed to continue on humanitarian grounds. While we will not interfere with this finding, we make it clear that other differently able candidates will not be entitled to the same benefit, as it would contradict legal principles and the rule of law. However, in consideration of their disability, these candidates will be permitted to continue and will receive wages until the fresh selection process and appointments are completed. Then, the disabled candidates mentioned in the previous paragraph will be allowed to participate in the fresh selection process if required with age relaxation and other concessions. Similarly, other candidates who are not specifically tainted will also be eligible to participate with appropriate age relaxation.
Not other concessions,
No,
only age
age
relaxation.
relaxation.
But in case of disabled, other
Disabled.
concessions and age
But
relaxation.
we are not here troubling the court with disabled candidates. In our opinion, such a direction would be fair. It would allow these candidates to take part in fresh selection process, which should now be initiated to fill the vacancies. Therefore, this is now being
Now, now I will ask you, Mr. Bhattacharya, where is the bar in framing separate rule?
First of all, don't say that they have no power to frame rules, but that rules will come prospectively. Here, the declared
No, in terms of the order of the Supreme Court.
Supreme Court always says, Supreme Court passes on at the point of time when the rules are prevalent.
Yes, but Supreme Court did not expressly debar
Did
the
not-
state authorities or the
question
recruiting
did not
authorities
arise.
from framing rules.
These questions did not arise at all. My lord will have to consider that when court is passing an order, keeping the law as it was then available. And when court found that the appointments of a particular selection is bad, court is permitting to do that selection afresh. If you do that selection afresh, you have to go back to that situation. You cannot come back later and bring something new. That would be really betraying the confidence of the court with the authorities. Therefore, 2016 selection should be made in terms of 2000 selections.
That is your submission.
That's my submission. And then kindly come to me, Lord. একজন বলতে দেবে আমাকে?
Yes.
Accordingly, paragraph 51, we uphold the impugned judgment cancelling our block entire selection process, but have made certain modification in the direction issued by the High Court. The appeal at this was so and so. However, we independently take up the issue raised in filed by the state. That's a different issue.
Now come to 17th April order.
Now kindly come to me, Lord, the application filed by them before the Supreme Court.
And the 17th April order is
Yes.
German.
MA, kindly come to me, Lord, MA.
ওইখানেই তো আছে
briefটা দেখাচ্ছি, briefটা দেখাচ্ছি।
এই কেসটাতেই আছে পেজ 86
Lord,
পেজ 86
briefটা বলছিল হাতের কাছে রাখবে।
আরে অর্ডার তো এইটা
Come to order dated 17th
But no
April.
order will be necessary. Let us see what was the application made. Copy through that. এত কথা বল, চুপ করে বসো তো। হয়েছে পুরো অ্যাপ্লিকেশনটা? Kindly takes up the application. which was-
Application, that is miscellaneous application 709,
Yes.
taken out by the West Bengal Board of Secondary Education.
What was the application for?
Page.
My lord will find that application on the next matter. And the
देखिए
relevant-
next ম্যাটারটা দাও তো।
Repeatedly বললাম applicationটা হাতে কাছে রাখো না। ওর থেকে নাও, দিয়ে দাও। একটু তৈরি থাকো না, যেটা করতে বলি শোনো। বিরক্ত লাগে।
Page applications next
Kindly
matter.
turn to that page, running page 188.
Yes.
So this is the application, also fine. This is the MA. They quote the order of the court. Then kindly come to paragraph 4. They have again quoted the order of the division bench.
ওরা ওদের মতো ওরা ওদের মতো বলবে আমরা আমাদের একটা বলবো কি হওয়ার কি
You kindly now come to paragraph 10. Pursuant thereto, a letter dated 22nd of April was sent by the Commissioner of School Education to all the district inspector schools in district, informing them about the order dated 17th April. Hereafter, the letters dated 23rd April were sent by the DI to all schools in the district, sharing a list of the assistant teachers who were not found to be specifically tainted. It is submitted that the names of the applicants do not find place in the said list. এটা কোন application দেখা যাচ্ছে?
But this is referring to 17th April 2025, Mr. Bhattacharya. We are on the order date 17th April 2025.
Kindly explain, Mullah, I am misled by my juniors, unfortunately. Kindly takes up the application filed by the board.
This quote is on 17th April 2025 order
Yes, the 17th April order was passed.
on an application.
I am not.
But this cannot be
No,
that
no,
application.
no, I am extremely sorry.
Yes, yes.
I am extremely sorry. My lord, their application is at page কোথায়? Look, this application was filed by the copy দাও তো ওখানে by the state. তোমরা রেডি থাকো না Lord, I just must read out Lord, the relevant portion. It is stated that Lord, the page paragraph 5 of the said application. Steps are being taken in terms of the judgment for filling of the vacancies which have arisen on account of the, well, I can note this, which have arisen on account of the selection process having been set aside. The applicant is informed that a letter dated so-and-so addressed by the state government to the West Bengal Central School Service Commission issued. By way of instant application, the appellant most humbly craves to seek appropriate directions and modifications of the judgment to permit the appointed candidates not found to be tainted to temporarily continue in the various schools without claiming an equity in their favor until the end of the academic year or until the process for fresh appointment is concluded, whichever is earlier, so that education of these schools does not suffer. That's the application. Now, my lord, I do not replace the other paragraphs, which is not relevant. Kindly see what are the prayer made. Prayer was, permit the appointees not found to be tainted to continue in service till the end of the academic year or until the process of fresh appointments to such posts. Underline this, Lord. Appointment to such posts is concluded, which was earlier. On the basis thereof, the Honorable Supreme Court passes an order at page 86.
That is 17th April order.
Yes. We are inclined to accept the prayer made in the present application.
Just
Repeatedly বললাম confused করে অন্য thing.
yes, 17th April. Yes, yes, yes.
We are inclined to accept the prayer made in the present application insofar as it relates to assistant teacher of classes 9, 10, so and so, not found to be tainted, subject to the following conditions. An advertisement for fresh recruitment to the aforesaid posts, no addition, shall be published before 31st of May 2025. Then the examination and entire recruitment process shall be completed by 31st December. These are the two things, Lord. Supreme Court says, do it to those posts by 31st May and complete by 31st December. Until then, the non-tainted will continue and get this.
I will permit you to read the rest of the
Yes.
orders. Now the problem is this: today, if court interferes with this selection process by making an observation or by setting aside this notification dated 30th May 2025, would it not lead to relaxation of time schedule fixed by this Supreme Court?
With deepest of respect, the court order, my lord, is not to be observed only to maintain the time schedule. The court order, my lord, has to be observed, and it is the duty of this court.
It is absolutely correct. It is under true letter and spirit. Now, but when with a default clause in 17th of April, this order was passed, then where is the scope left open to this court?
Yes.
To today, suppose hearing both sides, I set aside this notification dated 30th May 2025. Now that lead to relaxation of the time schedule or extension of time schedule by this court, that is according to this court is not open in view of the tenor of this court order dated 17th of April 2025.
But if your lordship finds that the first paragraph says advertisement for those posts is violated, will that be permitted? when the Honorable Court Lord is really thinking in terms that I have to,
That is troubling this court.
no, the court has to set aside. The Supreme Court judgments are there. Article 144 comes into operation. This will be duty of the High Court to ensure that the Supreme Court order is followed. Here, my lord, in the name of following the Supreme Court order and to avoid the wrath of the court, they have issued a notification. And if that notification seems to be apparently illegal, would the court, my lord, feel shy of not interfering? We want, let the time schedule as such be maintained, but you correct your notification. This can even be done by corrigendum. We want that this Supreme Court order, my lord, should be complied with.
Come to paragraph 3.
Yes. The state government, the applicant, West Bengal Board Education and the West Bengal Central Submission shall file their respective affidavits by 31st May, enclosing that with a copy of the advertisement for fresh recruitment, as well as the schedule therefore, so as to ensure completion of the recruitment process by 31st December. In case the advertisement is not published by 31st May and the affidavits are not filed, appropriate orders will be passed by this court, including imposition of cost. Now, to avoid this imposition, they have published a notification that 31st May. But is that the notification?
Now, what is the effect of the order passed by the Honorable Supreme Court dated 17th April 2025? That do this by this time, file an affidavit. So therefore, Supreme Court is still insisting of the matter.
So it's not insisting the matter. The Supreme Court dispose of the matter. Kindly it comes to us.
Then what was the purpose of calling for an affidavit disclosing initiation of the selection process by issuing this recruitment notification dated 30th May?
To ensure that this is done. Otherwise, the application couldn't have been disposed of. Kindly see the last thing. The application stands disposed of in the aforesaid terms. Court did not, my lord, keep any, my lord, control over the proceedings anymore. If it is to be done by my independent application. Now today, I was thinking aloud that if the Honorable Court
even Mr. Bhattacharya, even after disposal of the appeal by order dated by judgment dated 3rd April 2025, this miscellaneous application was entertained.
Was by the state.
Yes. So then where is the bar in approaching the Supreme Court for getting appropriate clarification?
We cannot approach.
But at the same time, the hand of this court is tied in view of the time schedule framed by the Supreme Court with a default clause, Mr. Bhattacharya.
My lord, kindly forget that the court is only bound to maintain the time schedule. Kindly think, court here sitting in the constitutional jurisdiction is my lord, also would be kind enough to consider
that a rule of law must be must prevail.
Supreme Court other directions. Supreme Court others directions in merit is not followed or not. Date is not only something which is directive.
But tell me whether this date extension of time can be relaxed.
I am not
because today we are in the mid of July.
Even then.
Now, if I set aside this notification dated 30th May 2025,
need not be set aside.
Then it will lead to extension of time for issuance of notification. Then today the resultant effect would be court has to give a direction upon the recruiting authorities and the state to frame a notification within fortnight or within 1 month. That will not lead to extension of time fixed by the Supreme Court.
Then the obligation would be upon the state and other parties that since this is the order due to, can you extend the time? But fundamental task would be.
So when you are approaching before this court, you approach the Supreme Court for extension of time.
Why should you? I have to first get a view that this is illegal. Supreme Court doesn't have the original jurisdiction to entertain a new notification. My lord is well aware that I cannot straight away go Article 32 petition filing a challenging notification. It would not be governed. Therefore, I have to approach the jurisdictional court, and if the jurisdictional court finds that this is illegal, then consequently I can approach the Supreme Court saying. Now, kindly, my lord, now since this is the order that here also on 13th of April, 17th of April, Supreme Court categorically states, you follow recruitment process to that post.
Advertisement for fresh recruitment to be.
Therefore, if those posts,
which paragraph? Clarify that all orders will.
Now, will kindly come to me, lord. Advertisement for fresh recruitment to the aforesaid posts. Aforesaid post means, my lord, the 2016 selection. Therefore, if it is confined to 2016 procedure and law, there is no difficulty. Even today, But they can issue a notification that this was a mistake. We will follow only 2016 rules and the vacancies.
And if aforesaid posts are clubbed along with the subsequent vacancies, where is the bar in the order?
Because under the rules, recruitment rules, you have
And
to,
how this can be restricted to the candidates of 2016?
because they,
Because that will in contravention of Article 16.
not at all.
It's a public
Public post,
employment.
well, the public employment for the vacancies declared. This is not a new process. But this arises because of intervention of the court. Well, had the court not declared the selection was over, then these vacancies wouldn't have come. Kindly consider this.
But nowhere division bench and Supreme Court has said, Mr. Nowhere, that this selection process has to be conducted in terms of 2016 SLST rules of 2016, and it would be confined to the vacancies.
So that I will then again,
Nowhere it has been
I will
observed.
again invite your lordship to read the judgment in its entirety. But what was the issue before the court? Kindly excuse me without deputation. That 2000 selection is bad.
Yes.
Now court finds 2000 selection is bad. Now court says do it afresh to those posts. Therefore, the rights of the parties which were there accrued at 2016 would be considered. The subsequent rights would never be considered because these vacancies were there in 2016. Categorically, High Court and Division Bench and Supreme Court says to those posts. Therefore, if it is confined to those posts, it will be confined to the persons who were then eligible. Otherwise, if 2016 election was not set aside, the subsequent vacancies, subsequent rules wouldn't have come into operation to tag with this. Couldn't have been. Therefore, reasonable and logical conclusion is that you have to hold afresh for 2016. Do it. We do not say that you cannot hold the examination.
So therefore, your sum and substance of your submission, Mr. Bhattacharya, is this: first, these vacancies of 2016, 9, 10, 11, 12 are to be treated separately, and for filling up those posts, this separate selection process is to be conducted following 2016 rules.
That's the judgment, number one. And number two, kindly will again come back to the impugn notification. The notification is still inherently bad. And the Supreme Court, Milord, makes it very categorical that the tainted candidates would be barred.
Yes.
Prohibition.
That's true.
And you have allowed everybody to participate. Number one. Now, kindly consider the notice is inherently bad. Now, kindly, Milord.
Now, notification, I would ask Mr. Bandyopadhyay two things. First of all, where is the prohibition prohibiting the tainted candidates to participate?
Right.
There is no such prohibition. And another thing, I would ask Mr. Bandyopadhyay to clarify that if you come to the mark provisions relating to allotment of marks,
I was going to say.
now they are
inherently bad. You are
that is also. বলতে আমার এই ইয়েটা কোথায় ওই লাস্ট ইয়েটা দাও তো ওখানে নোট করা আছে
Oh, you have come ready. That's good. The marks.
First of all, there is no express prohibition prohibiting the tainted candidates to participate. That you will, I know you will take this point. And the second is
Distribution of marks.
Distribution of marks.
The additional marks for teachers comes. Thereby, you want to give benefit to those who have been declared null and void by the Supreme Court. Distribution of marks. But that will also get blood in the rules.
Yes, that is in the rule. It is there. Yes.
Schedule 2. At page 1110.
This prior teaching experience,
Yes.
whether 10 marks can be allotted,
Yes.
who has lost their job with the finding that there is egregious fraud. So how this can be reconciled?
And then again, if it is about the open recruitment for fresh
10
recruitment,
marks for experience. Now, if a teacher who has rendered job in connection with 2016 SLST 9, 10, 11 and 12, how they will get
that
the
is,
marks?
you have correctly marked this. And then again, the distribution of marks was also changed
That I have seen.
to create another door for corruption. I use this expression with all restraint. Now you have seen these rules. Kindly come to this notification which is under challenge is of dated 30th May. And
Is there in the notification any provision that the tainted candidates should not be?
And this rule is published on 29th of May 2025. 29th May 2025 is the rule. And
30th May is the notification.
And there you say that we have additional vacancy in terms of 2025 rules. How could you arrive at the vacancy? If the rule was published on 29th of May and rule gives the detailed procedure for ascertainment of vacancies, how could you on the next day get the vacancies?
But I do not, Mr. Khobarhub, find fault with clubbing of vacancies along with subsequent vacancies. If those vacancies are included, matter ends. But the question is, where is the embargo
When the vacancies are included, you are
clamped upon the untainted candidate, tainted candidates?
So that is one part you have already taken note of. When you are adding the new vacancies, you are inviting fresh candidates. Just a minute. Now that you see the classification is so irrational. When you say that I add these additional vacancies, then you are inviting the fresh candidates who would be eligible today, and they will be putting in competition with the 2016 candidates.
Yes.
Is that fair? Apart from the question of distribution of marks, would that be fair? And when the Supreme Court and High Court says those vacancies only, because this is a fresh test of the persons who had participated. Today, they are thrown out. One group is completely banned, but another group is permitted that you participate and prove your worth. And if you now ask them to compete with the fresh students of 2025, that itself is illegal. That's why the rule says every year you have to assess the vacancies and publish the advertisement so that the fresh recruits can come and compete with the said vacancies. And clubbing of these two vacancies of 2016 and 2025 would be irrational and violate Article 14. You hold the examination separately for 2025. No problem. The fresh candidates will come and contest. Otherwise, you will be putting us in difficulty, who are really the genuine candidates contesting 2016. Now, this notification can even today be modified, corrected to respect the time schedule by the Supreme Court. 31st December, long way to go. Only this little modification that the portal is such that who have already crossed 40 years, they are not permitted to file, though the Supreme Court says age election should be given. The notification says the age relaxation as by the Supreme Court. If I am not allowed to enter, how would you assess whether I am age bar or not?
Yes.
Therefore, if your lordship just conclude, I will not take as prima facie case. The division bench judgment and the Supreme Court judgment, the court was always conscious of the fact that this 2016 should be done afresh. Nothing beyond that. Let them do it afresh. With the guideline, the tainteds are out and the age relaxation to the persons who had participated.
Yes, that is there in the.
No, but portal does not permit me to enter.
Age relaxation already there is a direction.
There is a direction, but I cannot apply The portal says they were barred.
Overaged.
Therefore, the portal should also be, my lord, corrected. Now, my lord, I just cite one judgment, my lord, relating to Mayawati's case, where, my lord, the CBI initiated a criminal case saying that the Supreme Court directed. The court declared this is void. You cannot say this. When the court does not specifically direct, you cannot take the advantage of this. Take it out. These applications will not filed by the state or the West Bengal secondary education supported by the state. That will not be filed at case 249 in the matter of 12512. Paragraph? Yes, yes. Now, this is 2012 8 SSC.